And Mr. Gould?
Felos.
Okay. Sorry, I was looking at the next case.
Mr. Felos, could you follow up with that last response? Because if you look at 765, it does address the question of the proxy and the proxy making the decision. Could you address the argument that in this case the judge became the proxy?
Well, Could you first introduce yourself, though, and tell us who you represent?
Thank you, Your Honor. I'm George Felos. I'm counsel for Mrs. Schiavo's guardian, Michael Schiavo. I'm here this morning with co-counsel Randall Marshall, who's the director of the American Civil Liberties Union of Florida, and also Mr. Thomas Pirelli of Jenner and Block, cooperating counsel with the Florida ACLU. And on behalf of my client, we did want to thank the court for accepting the bypass certification and expediting consideration of this case. And in answer to your question, seems to me that if you read the briefs to invoke this court's discretionary jurisdiction in Schiavo 1, these are the questions that we argued. Those were the arguments of Terri's parents in seeking review of the initial Schiavo 1 decision. Were the due process rights of the ward affected in by the trial judge having in essence acting as a proxy? And obviously this court didn't think so 3 years ago by electing not to take its discretionary jurisdiction. And I just want to highlight, in essence, what the governor is trying to do in this case is relitigate and force a re-adjudication of Terri Schiavo's rights, which have already been fully and finally litigated in the courts of the state.
The procedure that was followed was the procedure that was set forth in Browning and then is subsequently put into statutory format by the legislature, which anticipates that if there is a dispute between the parties, that the judge would set forth a decision. But if prospectively the legislature determined that there should be a procedure that, say, takes the initial aspect of this very, very private decision out of the court and starts with some administrative process, and requires there be a guardian ad litem appointed for an incompetent adult, would you see any constitutional infirmity in such an act? And how does what we have in front of us differ from that?
Yes, Your Honor, I would see constitutional infirmity for a number of reasons. First off, from the aspect of the constitutional right to privacy here, the violation here is taking from the patient and giving to the state the power to make medical treatment choices. And if you're contemplating a procedure in which the current format of having a guardian, a spouse, an adult child, close family members make a decision for an incapacitated patient, and you remove that and give that decision making to the state, even if it's in the context of a legislative scheme, yes, I think there are problems.
But isn't that what we do with Department of Children and Families? In other words, when we're in a situation where we're concerned whether the rights of an individual who cannot express himself or herself either by minority or by incompetency, the idea of having additional procedures to make sure that the state's interest in preserving life is honored, and that is the norm. Why wouldn't a procedure like that be appropriate? And isn't that what they are trying to do, maybe belatedly, in this situation?
Well, Your Honor, I would disagree that's what they're trying to do belatedly. I think, as Justice Wells stated, it's obvious here that the intent of the legislature here was to overturn a judgment, a final judgment of the court of this state that they were particularly displeased with. But getting back to your question, Your Honor, a guardian is already appointed under Chapter 765, and if you ask, can we take an administration of a patient's constitutional rights or a dispute and take it out of the court system into another forum, I guess I would want to know what type of forum there is and who the decision maker is. You have to remember, these are intensely personal and private rights we're talking about here.
Let me ask you, your opponents make the point that we are not really, though, talking about a judgment which was final, since this issue in this guardianship is not final as long as Ms. Schiavo is still alive. Now, what is your answer to that this is always a prospective type of situation?
Your Honor, this is a final judgment for a number of reasons. Number one, it was a final statement or final word of the court system of the state of Florida. It was acknowledged by the Court of Appeal many times as a final judgment, also appealed as a final judgment. But the fact, Your Honor, that under our system of justice, under the rules of procedure, a final judgment can be vacated under certain grounds, and in this ground, and the purported grounds here is Rule 1.540B5. The fact that a final judgment could be vacated in the future doesn't make it any less final for separation of powers. To follow that logic, Your Honor, every civil judgment in this state would no longer be final and subject to legislative rescindment because it could be vacated, potentially vacated, under Rule 1.540B5.
Would the governor file a motion under 1.540B5 right now, or any other subsection of 1.540 saying circumstances have changed or there's new evidence?
Your Honor, I don't believe so. I believe that 1.540B5 is concerned and pertains to parties in the case. But I also did, because it's a very important point as to whether this is a final judgment, because that triggers the separation of powers analysis, Your Honor. Your Honor brought up the analogy of a child custody case. It is very true that in a family law situation, when a judge awards a custody of a minor child to one parent, that becomes a final judgment. It can be appealed, but the trial court or the family law court retains jurisdiction over that case, over that child, until the child reaches emancipation. And under that theory, because the trial court could address the custody issue at some time in the future, if we're saying that's not a final judgment, then the separation of powers protection, the firewall of separation of powers, is eradicated in family law cases, and that's certainly not the law of this state.
Can you address the governor's argument or counter-argument to that he's not bound by that? If it's a judgment, he's not bound by that judgment because he wasn't a party to that proceeding, and therefore collateral estoppel or res judicata principles would not apply to him?
They don't have to apply, Your Honor, because that's a red herring issue. The fact is, the fact that he was not a party to the judgment does not alter the fact that the judgment was entered. And if we follow that logic, well, the governor for separation of, or the legislature can rescind judicial judgments to which the legislature or governor were not a party, well, then the vast majority of judgments would be subject to legislative rescindment. And
is there any, if the governor cannot intervene based on Rule 1.540, is there any procedure by which the governor could, in fact, have intervened in this proceeding?
I don't believe so, Your Honor, but the state's interests are protected. If you, in these cases, if you read Browning, if you read the Dubril decision, the Wands decision, this court was very clear to say, and it arose in the context of a health care provider. If a health care provider disagrees with the patient's medical treatment choice, do they have standing to contest it in court? This court said no. What the health care provider would have to do is go to the state attorney and give this information to the state attorney, and it would be up to the state attorney to decide whether to intervene in a particular case. So it's not to say that the state's interest in preserving life or whatever interest they might assert cannot be addressed, but not by the governor.
Can I ask a question? In the second DCA's opinion of July of 01, it refers to the judgment specifically, or the order in the terms of a mandatory injunction and not as a final judgment. and it says, until the life-prolonging procedures are discontinued, such an order is entirely executory, and the ward and guardian continue to be under the jurisdiction and supervision of the guardianship court. As long as the ward is alive, the order is subject to recall and is executory in nature. Address that in the sense of finality.
Yes, but if you also look, Your Honor, at that opinion, the Second District, I believe it was in Schiavo 2, specifically refers to the order of the guardianship as a final order. And the Second District also said the procedure by which that order could be reopened is the 1.54B5 procedure. And I think it is absolutely extraordinary for the governor to argue that the legislature in 18 hours and the governor in a matter of hours somehow possesses some inherent wisdom in regarding the matters of Terri Schiavo that could not have been ascertained by the justices of this state in over a 6-year period. And
let's approach that just a little bit.
Yes.
I mean, are you suggesting that the legislative power can never be exercised to protect disabled children? In this state, we have numerous children in this state are disabled and cannot make decisions for themselves. Are you suggesting that the legislature cannot come in and place safeguards to protect the well-being and the virtual life of these disabled children?
Absolutely not. But Terri Schiavo was a competent adult who expressed medical treatment choices.
Well, now you're going into the procedure. Are you suggesting that the legislature could not prohibit this kind of procedure, that you must have something in writing, you must have a procedure other than someone's friend coming in and expressing what they think the person wants? We didn't have the testimony of Ms. Schiavo in this case, did we? It was all testimony of other individuals.
Of other individuals.
And that would always be the case, would it not, with incompetents and disabled children in the state?
Your Honor, but to answer your question, if the legislature amended Chapter 765 and said, we're not going to permit removal of artificial life support unless somebody has a written advance directive, no, that law would be unconstitutional, because this court has declared in the Browning case that in order to recognize and implement an individual's right of privacy, oral declarations are sufficient to establish, as long as they're by clear and convincing evidence, the intent of the patient. So such a legislative enactment in that case would be, in my opinion,
so you are saying that the legislature cannot come up with criteria contrary to the way that the judicial system has interpreted a privacy right. That's the fundamental base of your argument, then.
I would say, Your Honor, that the Browning case provides the minimum right of privacy that a patient is entitled to. And the legislature may certainly legislate in the field to protect the public and to make sure that the right of privacy is effectuated.
But we're really
they can't fall below that minimum.
But I mean, now, in the Cruzan case, if you look back at what the Supreme Court in Missouri did, they essentially decided that the testimony of a neighbor was not clear and convincing evidence of the person's wishes. So, I mean, if we're getting, and probably we may be getting a little far afield of what we have to decide in this case, but because the issue isn't whether the legislature could enact something much more comprehensive to better address this type of situation, which is it's getting tragic for everybody. So could you get back to the issue on, with the separation of powers, could the legislature, if this wasn't Terri Schiavo, we're just looking at the facial challenge, what is wrong with what the legislature did in this case as far as giving this power to stay for one time the withholding of hydration on a one-time basis?
Aside from the intrusion into the judiciary, which is the separation of powers violation as applied to Terri Schiavo.
That's the as-applied challenge.
Yeah. As to the facial challenge, there are two. The impermissible legislative delegation. As as Your Honor mentioned, there are no standards. Now, the test for impermissible legislative delegation is this. Could a court, in reviewing the decision, be able to ascertain whether the decision maker acted with indiscretion or abused discretion? And that statute fails in this way. If there were judicial review permitted, and of course there is no judicial review, so that could never occur in this case, but if there were judicial review, how would we ever know, how could we even begin to make that determination when we don't even know what the basis for the governor's decision is? Because he's not required under this act to tell us the basis of his decision.
Well, can you address the governor's arguments, your counsel's arguments that you have to read this act in pari materia with Chapter 765 and I believe 764, and those provide the guidelines?
That doctrine, Your Honor, only pertains to situation where there's ambiguity in the statute. This court held in Holly versus Auld that if there is no ambiguity, facial ambiguity in the statute, that this court can't resort to that type of statutory interpretation. So that doctrine doesn't apply here. We're not talking about an ambiguous statute. This statute is crystal clear what it does. It gives the governor unfettered and absolute authority, but to follow that, even if the governor did tell us or could be compelled to tell us what the basis of his decision was, there's no standards to apply. How do we know whether the legislature wanted the governor to consider a cost-benefit analysis for providing medical treatment? How do we know whether the legislature wanted the governor to take into account family wishes rather than the wishes of the patient? How are we to know whether the legislature wanted the governor to act in the best interest of the patient as opposed to determining the subjective intent of the patient?
Based on this statute, can anyone lift this stay? Can this stay be lifted?
No one standing here.
Was there any attempt to do that in the proceedings below, to have the stay lifted? Or was it was only an attack on the constitutionality?
On the constitutionality, Your Honor. I don't believe Your Honor, I don't believe the statute provides any mechanism to have the governor's decision reviewed.
So what is the point then of that part of the act which says that you then appoint a guardian who reports or makes recommendations to the governor and the court?
Well, I believe the statute says it makes recommendations to the governor. In terms of power and authority, there's no point. We don't know whether the governor read the report or didn't read the report, or if he did read the report, took it into consideration, or picked it up and tossed it away. So as far as the statute itself, it changes nothing as to the impermissible delegation of authority. But I also, since I only have 2 minutes left, Your Honor, wanted to address the facial unconstitutionality regarding the right of privacy. And I touched on this before. The essential issue here is who is entitled to make a decision on a matter so personal and private as whether one would want artificial life support. Does that power constitutionally reside with the patient, or does that power reside with the state?
Do you agree that if we hold that this statute is unconstitutional as a violation of separation of powers, or at least as applied to Terri Schiavo, it's unconstitutional, it's basically not going to apply to anybody else? So by holding it's unconstitutional as applied, we're really saying it's unconstitutional as its face as well, practically speaking. It's not going to apply to anybody else, is it?
It's not going to apply to another case, but we would ask this court, of course, specifically to find that it's unconstitutional as applied to Terri Schiavo because it's an unlawful intrusion into judicial power for this reason. If this court only found the statute facially unconstitutional, let's say for improper delegation of legislative authority, we don't want, and chose not to address the as-applied separation of power argument, we don't want to be here a year from now arguing the constitutionality or unconstitutionality of Terry's Law 2. This young woman has a right to have her final adjudication honored by the courts of Florida. This unlawful intrusion into that right should be overturned and definitively overturned so her right to privacy can be effected.